Okay, 9 o'clock. We're ready to start. This is the State Ethics Commission, and I think you all know Mrs. Palma, Mr. Carter, Vice Chairman, Robert Hitty, the attorney, Robert Caruso, the Executive Director, Brian Jason is the Executive, and he's playing a good role in that. So let me start by saying that pursuant to the public official, the Employee Ethics Act 170 of 1978, as amended by Act 9 of 1989 of June 26, 1989, as amended by Act 93 of 1998, the State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg, to specifically seek input from persons and organizations who represent any individual subject to the provisions of this Act, and from other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive the input or testimony of said individuals pursuant to the provisions of the law. As our previously published notice has indicated, the Commission will request copies of any statement that is presented. The individuals presenting statements before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting prior to said executive session and the public meeting thereafter. Executive meetings were held on July 27th, August 10th, September 20th, and October 19th, 2016 to review matters that are by statute 65 PA 708 1107 1108 confidential reporting, to discuss internal commission case procedures, to review a motion for reconsideration, to review and consider applications for 90-day extensions and investigations filed by the investigative division, to consider changes in the commission's pay system, to review completed investigations for purposes of issuing final adjudications, and to review and consider terminating certain preliminary inquiries recommended by the investigative division. First item on the agenda is approval of the July 27, 2016 public meeting minutes.
So moved.
Motion by Mr. Corrigan, second by Mr. Palmer. All those in favor signify by saying aye.
Aye.
The first item on the agenda, we are going to have requester C.J. Hafner, who is the chief counsel for the Pennsylvania Senate Democratic Legal Staff. Mr. Hafner.
Good morning, Mr. Chairman, and thank you, and good morning, Commissioners. Can everyone on the phone hear me?
Roger, can you hear me?
Yes, I can.
Okay.
Very good. Okay. As I stated in my letter of October 13th to Chief Counsel Hitty, I'm here on behalf of Sean Logan, who is chairman of the Turnpike Commission. And on behalf of Chairman Logan, I want to thank the Commission for hearing his request on such short notice. Also want to thank the Commission's Chief Counsel for her assistance and guidance in placing his request and supporting documents before the Commission. She was very helpful. I have 2 points I want to raise, one minor correction and one clarification. If the Commissioners would turn to page 2 of my letter, the first paragraph, that should read Chairman Logan, not Senator Logan. Senator Logan is a prior member of the State Senate. I'm afraid I was having a flashback there for a moment, and I didn't catch that in the editorial, in the proofreading. And the clarification is on page 3, the last paragraph before the heading public official. This is the paragraph that cites to the Allegheny County Ordinance 04-16-09, the citation to 53 consolidated statutes. That was contained in the ordinance, but for the Commission's information, that was repealed approximately 1 month. The statute was repealed approximately 1 month after the ordinance was adopted, and it was replaced by Act 18 of 2016. And with that, I'm going to conclude my remarks. And again, I want to thank the chair, the commissioners, and the chief counsel for their expedited action on Chairman Logan's request. And I will attempt to answer any of your questions. Thank you, Mr. Chairman.
Questions?
Yeah, just for the record and for like background for folks in public viewing and for everyone else here, I have an opening statement, and then if there are any questions after that, there may be. So just for background, the requester is C.J. Hafner II. Mr. Hafner is Chief Counsel of the Pennsylvania Senate's Democrat Legal Staff. The individual who is the subject of Mr. Hafner's request is Mr. Sean Logan. The question presented is whether Mr. Logan serves as Chairman of the Pennsylvania Turnpike Commission and as Executive Director and Chief Executive Officer of the Convention Visitors Bureau of Greater Monroeville would bring Mr. Logan within the definitions of the terms executive level, public employee, and or public official as set forth in the Gaming Act at 4 Pennsylvania Consolidated Statutes, sections 1103 and 1512B. The Commissioners have all received extensive submitted facts which address Mr. Logan's roles with both the Turnpike Commission and the Visitors Bureau. Mr. Logan is Chairman of the Turnpike Commission. The Commission is an independent agency of the Commonwealth. The request states that the Turnpike Commission has no duties involving licensing or enforcement related to the Gaming Act. I would note that in Alfano, Determination 14-2001, we previously held that a member of the Turnpike Commission is not a public official as the Gaming Act defines the term. Mr. Logan is also Executive Director and CEO of the Convention Visitors Bureau of Greater Monroeville, which I shall refer to as the Visitors Bureau. The Visitors Bureau was originally incorporated in 1980 as a nonprofit, non-stock Pennsylvania corporation. However, in March 1991, the Council of the Municipality of Monroeville, Pennsylvania, adopted an ordinance creating the Greater Monroeville Convention and Visitors Bureau Board for the municipality. Council created the Board of the Visitors Bureau pursuant to its authority under the Monroeville Home Rule Charter. The ordinance that created the Board of the Visitors Bureau has several amendments. The most recent ordinance establishing the board is Ordinance Number 2314, effective December 2004. Ordinance Number 2014, together with Sections 1801 and 1802 of the Monroeville Home Rule Charter, provide that the municipality of Monroeville creates and establishes the Board of the Visitors Bureau as a municipal board, with the board members appointed by the municipal council. Section 2 of the ordinance, number 2314, provides the board shall be vested with all and full powers and authority as delegated to it under the Home Rule Charter of the municipality and the second-class county code, and with the right to have full and complete control over the operation and conduct of the efforts of the municipality to plan and promote programs designated to stimulate and increase the volume of tourism and visitor and convention business in Monroeville. The ordinance provides the Board of the Visitors Bureau to receive appropriations from the municipality. The Visitors Bureau also receives funding as a tourism promotion agency pursuant to Section 1407 of the Gaming Act. Mr. Logan estimates that the Visitors Bureau receives less than 15% of its funding from gaming revenues. Additional funding is generated by a hotel room rental tax, which is imposed by Allegheny County pursuant to state law and an Allegheny County ordinance. The request before us states that the Visitors Bureau is not involved in the development of law, regulations, or policies relating to the Gaming Act. However, the request acknowledges that members of the board of the Visitors Bureau are included on the list of positions this commission considers to fall within the definition of the term public official as set forth in the Gaming Act. We have received a copy of Mr. Logan's job description for his position with the Visitors Bureau. The request states that as Executive Director and Chief Executive Officer of the Visitors Bureau, Mr. Logan does not possess discretionary powers or authority related to the Gaming Act. The request also includes a copy of the letter dated February 2016 from the Pennsylvania Department of the Auditor General, which concluded that employees of the Visitors Bureau were not employees of the municipality for purposes of Pennsylvania's Municipal Pension Plan Funding Standard and Recovery Act. I wonder whether anyone might have any questions before we move forward.
Do you have any questions? No?
I have a couple. Just to confirm my understanding of the materials you submitted, with regard to the Visitors Bureau specifically. So Mr. Logan is the Executive Director and CEO, but he is not in any way treated as a board member.
Correct.
He's just an employee.
Correct.
Okay. And then the only connection I could see that this Visitors Bureau has with gaming at all is that they receive the gaming revenue. They have nothing else to do with gaming, is that correct?
That's correct. And I would just reiterate what Commissioner DePaul read, and that is less than 15% by Chairman Logan's estimation.
Any questions? Roger, do you have any questions?
No, I'm good, thank you.
Any questions?
No, it's go forward.
If there are no questions, then we can.
I'd like to just state one more thing for the record, that in comparing the two definitions of public official, we noticed the General Assembly chose to make the receipt of distribution of gaming revenue a basis for a status as public official, but did not include the receipt of a distribution of gaming revenue as a basis for status as an executive level public employee. As an administrative agency, it's our duty to apply the definitions as promulgated by the General Assembly. In doing so, it's my view that neither of these definitions applies to Mr. Logan. As chairman of the commission, Mr. Logan is not a public official as the Gaming Act defines that term, as long as the material facts remain the same as they were in our Alfano Determination 14-2001. As executive director and CEO of the Visitors Bureau, Mr. Logan is not a public official as the Gaming Act defines that term, because he's not a board member, he's only an employee of the Visitors Bureau. Additionally, the definition of executive level public employee does not apply to Mr. Logan in either of his roles, because Mr. Logan's duties do not involve licensing or enforcement under the Gaming Act, discretionary powers that may affect or influence the outcome of actions or decisions related to the Gaming Act, or the development of law, regulations, or policies relating to a licensed entity or matters regulated under the Gaming Act. When you apply each paragraph of the Gaming Act's definitions to the submitted facts, point for point, not one of them fits. Therefore, it's my view that Mr. Logan is not a public official or executive level public employee, as the Gaming Act defines those terms. And again, it's important to note that we're not determining Mr. Logan's status under the Ethics Act definitions. We're determining his status under the Gaming Act definitions, which are different. So that makes it.
That's a motion.
So based upon the submitted facts, I'd like to make the motion that service as chairman of the Pennsylvania Turnpike Commission and/or executive director and chief executive officer of the Convention Visitors Bureau of Greater Monroeville would not bring Mr. Sean Logan within the definitions of the terms executive level, public employee, and/or public official as set forth at sections 1103 and 1512B of the Gaming Act. The Public Official Employees Ethics Act contains a different definition for the term public official, and this determination under the Gaming Act does not address or impact the status under the Public Official and Employee Ethics Act. Mr. Chairman, that is my motion.
Second?
Second.
Second by Mr. Corrigan. Any questions? Roger, you have a question?
No,
Very good. So the motion has been made by Mr. Palmer, seconded by Mr. Corrigan. All those in favor of the motion signify by saying aye.
Aye.
Nay? The ayes have it. Thank you very much for
Thank
making
you,
the trip.
Thank you, Mr. Chairman. Thank the commission. I got to see part of the state I haven't been.
And Route 70, that's a nice drive.
Yeah, 68 and 70 were very nice drive. There's one question, Mr. Chairman, not to put pressure on Chief Counsel. Can I have an estimate of when we will receive a written opinion? Just an estimate.
I would say within about a week at most.
Thank you very much. Thank the Chief Counsel. Thank you, ladies and gentlemen.
Do you need one earlier because?
No, sir.
Okay.
We'll just rely on the motion for now, and I'm sure that'll be sufficient.
Okay.
Thank you.
Thank you.
Okay, with that, under ethics, we have Mr. Corrigan, who I think is going to do Clemic and Lozano together, right?
With the indulgence of the commission, I would do that because Mr. Clemic and Ms. Lozano have filed the same appeal, the same factual situation. They work in the same office and they have the same job title. The appellants are Mr. Joel Clemic and Ms. Lozano, and they are employed as highway design supervisors with the Pennsylvania Department of Transportation under the job code number 10330. Advice of Council 16544 was issued to Mr. Clemic and one to Ms. Lozano. The advice determined that in their capacity as the highway design supervisors with PennDOT under their job code, they are public employees subject to the Ethics Act and the regulations of this commission, and in particular the requirements for filing statements of financial interests pursuant to the Ethics Act. They appealed their advices of counsel, but did not state any particular basis for the appeal or submit any additional facts to this commission. Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak on this matter. There is nobody here. Mr. Chairman, I have reviewed the facts and the relevant statutory provisions. As the commissioners are aware, we must apply the judicially approved objective test to their duties as set forth in their position descriptions and job classification specifications. Having reviewed their position descriptions and job classifications, I agree with the advice of counsel. Their authority to perform the duties highlighted on pages 6 and 7 of the advices of counsel bring them squarely within the Ethics Act's definition of public employee. To mention a few of these, they both have the authority to control costs within programmed amounts on all projects, monitor project budgets, and provide required changes for all projects as necessary to the district plans engineer, coordinate and monitor design development costs, prepare contract special provisions, act as project manager on projects, resolve highway design related problems that develop during construction, supervise others, initiate corrective disciplinary action for minor misconduct by employees, and recommend major corrective disciplinary actions or dismissals, and approve leave, schedule personnel, and authorize or assign overtime. Based upon my analysis and comments, I would like to make the following motion: that in their capacity as highway design supervisors with the Pennsylvania Department of Transportation under Job Code 10330. They are public employees, subject to the Ethics Act and the regulations of the State Ethics Commission, and they are required to file the statements of financial interest pursuant to the Ethics Act. The appeal is denied. Advice of Counsel 16-544 is affirmed.
Excuse me, Mr. Chair, if the motion could also just mention the advice number of.
Of Ms.
Yes.
Ms. Lozano's.
Mhm.
Yes, I don't have that right up here.
That would be-
It's 16-545.
A motion is second.
Second.
Mr. DePalma seconds the motion. All those in favor signify by saying aye.
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 Nay, the ayes have it. Item 4 deals with civil penalty orders, and I think there are 9 defaults. Roger, would you like to take care of this one?
Certainly, and similarly, 4 and 4A are both civil defaults, civil penalty orders, so I'll combine them as well.
Okay,
There are 11 civil penalty default cases that are now before this commission for decision. The respondents involved in these cases will be identified individually in the motion I will be making with regard to these cases. These respondents failed to file one or more statements of financial interest of the calendar years that I will detail in my motion. These respondents did not take action or respond to the civil penalty proceeding. Following review, it is my opinion that as to each of these respondents, the commission should levy a maximum civil penalty of $250 for each delinquent statement of financial interest. It is my opinion that the commission should also order these respondents to file their delinquent statements of financial interest. There is nothing of record that would constitute a defense or excuse for their non-compliance. Based upon my thoughts and comments, I would like to make the following motion. I move that this commission levy maximum civil penalties against the respondents in these 11 civil penalty default cases as follows. For the following 9 respondents, I move that this commission levy a maximum civil penalty in the total amount of $250 against each respondent for failing to file a statement of financial interest for calendar year 2014. Thomas Matkowski, William Thompson, Tina Colson, Matthew Cornell, Ed Mima, Jonathan Surfath, James Williams, Stephanie Rose, and Daniel Reed. For the 10th respondent, David J. Cole, I move that the commission levy 2 maximum civil penalties in the total amount of $500 against respondent Cole for failing to file statements of financial interest for calendar year 2013 and 2014. For the 11th respondent, Richard Reedy, I move that this commission levy 3 maximum civil penalties in the total amount of $750 against respondent Reedy for failing to file statements of financial interest for calendar years 2012, 13, and 14. Further, all the respondents shall be ordered to file a statement of financial interest for the year stated within 30 days of issuance of the commission's orders. That's my motion.
thank you very much, Roger. Second,
Second.
Mark Corrigan. Any questions? All those in favor signify by saying aye.
Aye.
Nay, the ayes have it. Thank you very much, Roger. Now we'll get into the, yes, did you want to say something?
Oh, no, I said certainly, yes.
Okay. The next item of business is the lobbying area administrative penalty orders consents. Mrs. DePalma.
There are 3 administrative penalty cases under the lobbying disclosure law with proposed consent agreements for our consideration. The following respondents are principals that failed to timely file a quarterly expense report for 1 quarter, specifically either the 4th quarter of 2015 or the 1st quarter of 2016, in their capacities as registered principals. The first is Phone Recovery Services, the second, Mid-Atlantic Community Papers Association, and the third, State Voices. The consent agreement for the Mid-Atlantic Community Papers Association recommends that the Commission find no violation as to the delinquent filing for the first quarter of 2016 due to the fact that Mid-Atlantic Community Papers Association had terminated the registration statement on January 28, 2016, and a technical error with the Department of State's electronic filing prevented it from timely filing its first quarterly 2016 expense report, which was eventually filed on July 26, 2016. Mid-Atlantic Community Papers Association has agreed to pay and has already paid $500 to the Commission, representing a portion of the costs incurred by the Commission in the investigation and enforcement of the matter. In each of the other two cases, consent agreement recommends the finding of a negligent failure to comply with Section 13A05 of the Lobbying Disclosure Law, and the respondent has agreed to pay an administrative penalty and cost reimbursement. Respondent State Voices has already paid its agreed-upon administrative penalty and cost reimbursement and has filed its delinquent expense report. Respondent Phone Recovery Services has filed its delinquent expense report but has not yet paid its agreed-upon administrative penalty or the cost reimbursement. Based upon my review of the facts, I'm of the opinion that the consent agreements are proper dispositions for the respective cases, and I would like to make the following motion, Mr. Chairman. I move that this Commission approve the consent agreement submitted by the Investigative Division and Respondent Mid-Atlantic Community Papers Association, and that Mid-Atlantic Community Papers Association is directed to pay the agreed-upon $500 payment to be made to the Commission, representing a portion of the costs incurred by the Commission in the investigation and enforcement of the matter. I further move that this Commission approve the consent agreements submitted by the Investigative Division and Respondents Phone Recovery Services and State Voices and impose the following administrative penalties. As to Phone Recovery Services, one administrative penalty in the amount of $2,675 for its delinquent expense report for the fourth quarter of 2015. And as to State Voices, one administrative penalty in the amount of $3,150 for its delinquent expense report for the first quarter of 2016. I further move that the Respondents Phone Recovery Services and State Voices are each directed to pay the agreed-upon $250 payment to be made to the Commission, representing a portion of the costs incurred by the Commission in the investigation and enforcement of their respective matters. Finally, I move that Respondent Phone Recovery Services, which has not yet paid its administrative penalty or additional payment of $250, is directed to do so within 30 days of the mailing date of the Commission's order. Mr. Chairman, that is my motion.
Second,
Second.
Roger. All those in favor signify by saying aye.
Aye.
Nay?
Aye.
It passes. We're going to talk about the ratification of the standard pay scale and employee increments. Mrs. Feely couldn't be here today, and Mr. Crusoe, do you want to address that?
Yes, I'll take that, Mr. Chairman. At the September executive session meeting of the Commission approved the movement to the standard pay scale enacted by the executive branch and also authorized increments for the Commission staff in line with what the governor had agreed to with the various unions in the Commonwealth. And it was approved at an executive session, and now it just needs simple ratification at a public meeting. We would need a motion for that.
Any questions? Can I have a motion?
I'll make the motion.
Mr. Palmer makes a motion.
Second.
Second by Mr. Corrigan. All those in favor signify by saying aye.
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 Aye. Ayes have it.
Any public comment?
There were no payments scheduled to record this thing.
If anyone wants to make a public statement, you're more than welcome to do so. If not, I have a motion to adjourn. Oh, I'm sorry.
Good morning. My name is Larry Strack. I'm the director of Waynesburg University's Stover Center for Constitutional Studies and Moral Leadership. on behalf of President Lee, just wanted to welcome you all again to Waynesburg University and thank you for traveling to this corner of the Commonwealth, and we hope that you'll come again.
Thank you very much. Your hospitality was very, very nice last night. We really appreciate it. The food was excellent, and we appreciate all the time you spent with us. That's it.
Move we adjourn, Mr. Chairman.
You make a motion?
Yep.
Second by Mr. Paul. All those in favor, signify by saying aye. Aye.
Aye.
Nay, the ayes have it.